Welcome everybody. My name is Lawrence Youssefian. I'm a barrister at Goldsmith Chambers. I specialize in UK immigration, asylum, and nationality law. Today's webinar is on sole responsibility under paragraph 297 of the immigration rules. I appreciate that it's not the fanciest or the sexiest topic, but I think it's a very important area of immigration law that can be often overlooked. And in my capacity as a barrister, I've been seeing a lot of refusals under this rule coming to me at the stage of appeal. And I felt like there's actually a lot more that can be done to, one, either avoid a refusal or to have a far stronger case by the time the appeal comes to a hearing. So we don't have that much time. I don't get to delve into the deepest corners of the law and analysis, etc., but I'm hoping to provide some form of a helpful overview and best practice guide. Before I begin, three things. First of all, you may have noticed that there's a call for donations for a particular charity. I've chosen BID as my Bail for Immigration Detainees as my charity of choice. If you feel so inclined, please feel free to donate. Instead of paying barristers for these webinars, we are asking for people to donate small amounts of money to these charities. BID does really important work for detainees, immigration detainees, for free. There is going to be a short time for Q&A at the end, so if you have any questions, please feel free to post them in the Q&A section. And finally, this video is being recorded currently, and so my slides and the video recording will be available later on our website and YouTube channel. But if you want my slides ASAP for whatever reason, feel free to send me a private chat on Zoom, and I can send you the slides by PDF by the end of today. Right, so sole responsibility requirement under paragraph 297 of the immigration rules. Now, you may be familiar with this by now. This is the requirement if you want to bring your child into the UK. So let's say you are a parent, a UK parent, and you are trying to bring your son or daughter into the UK. You have indefinitely to remain or as a British citizen. Now, the requirement that you seek to satisfy is this one under 297, which is the requirement to have sole responsibility. This is what we're going to be looking at today, this requirement in particular. One thing before I move on, I want you to also take note of paragraph 297(1)(d), which states, in contrast to E, it says one parent is present and settled in the United Kingdom or being admitted on the same occasion for settlement, and the other parent is dead. Now, what's important here and what's noticeable here is that there is no requirement of sole responsibility. And I find that rather odd. And perhaps there is a way to use this to our advantage. And I'm going to come to this immediately now. So first of all, TD Yemen is the case that you should be all familiar with. It's the most important case law perhaps for sole responsibility cases. And here at paragraph 48, it states the purpose of 297 is clear. It is designed to maintain or affect family unity. The end product is that the parents and child live together in the UK. Only if one parent is dead will the other be able to be in the UK alone with the child. By contrast, paragraph 297(e)(1) or 1e is concerned with settlement when one parent is in the UK and the other is abroad will remain so. So this paragraph has a potential to split up a family and separate a child from one of its parent abroad who is involved in its life. It is only the requirement of sole responsibility which acts as a control mechanism. It would, in our view, usually run counter to policy of family unity to admit a child for settlement where the parent abroad is caring for the child and involved in its upbringing, unless the requirement of paragraph 297(1)(f) are met. And this I will speak about at the end, 297(1)(f). This must be borne in mind, interpreting and applying the test of sole responsibility. But what's interesting is the paradigm case under sole responsibility in paragraph 297 is a parent who comes to the UK, has their child is then cared for by a relative or a grandparent of some sort in their home country. The parent in the UK obtains indefinite leave to remain or British citizenship, and for instance, the other parent who is in the home country has had no involvement in the child's life since birth. That's quite a common case. In that situation, even though the parent has had no involvement, the parent in the home country has had no involvement whatsoever with the child, you still have to show that you have sole responsibility from the UK. And then the question often is, well, what are the relatives in the home country doing? Maybe they have some responsibility. But if the other parent has passed away and doesn't have any involvement, obviously, because the parent has passed away, then you don't have to show any requirement of sole responsibility, even if there are relatives caring for your child abroad. But there is, when you think about it, there is no distinctly comparable difference between, for instance, a father who's been absent from a child's life since birth and a father who has sadly passed away. And so that really, for me, is a way to show and argue to the tribunal that the purpose of paragraph 297(1)(e), the sole responsibility, is to ensure that the parent and child remain together. And perhaps, obviously, the judge has to apply the rules as they are, and I'm not suggesting that you proceed with Ul-Jawar's argument in the first-year tribunal or in an application to the Secretary of State. But what you can do is draw to the attention of the tribunal or the Secretary of State the previous subparagraph here, and say this is the circumstances here are akin to the other parent being dead. And therefore, when you're looking at the question of sole responsibility, the tribunal should be more prepared and ready to accept the evidence of sole responsibility and not treat it with excessive skepticism as to whether the relatives abroad are caring or sharing responsibility with the sole parent in the UK. So I think that's an important point to bear in mind when making arguments and making representations to the Tribunal or Secretary of State. So now, nevertheless, the judges and Secretary of State have to apply the test of sole responsibility, and paragraph 52(9) of TD Yemen says the test is not whether anyone else has day-to-day responsibility, but whether the parent has continuing control and direction of the child's upbringing, including making all the important decisions in the child's life. If not, responsibility is shared and not sole. So we all know this more or less. It's not about day-to-day responsibility of caring for the child, because that's going to be necessarily the case since the child is presumed to be abroad. So if your relative is taking care of your child, that's not a problem. If your relative is feeding them, bathing them, taking them to school, making sure that they brush their teeth, etc., those are responsibilities for the day-to-day care of a child, and that's not going to preclude you from having sole responsibility. What the tribunal is concerned with, and the Secretary of State, is whether though the relatives abroad are exercising control or exercising direction, making decisions in any aspect or in important aspects of the child's life. And that's really what you need to focus on. So the starting point, we know, if one parent has disappeared from the child's life, in my earlier example, so if the father or the mother really has disappeared from the child's life, then the starting point is that the remaining active parent in the UK has sole responsibility. But as Baidov made clear, this is not a legal presumption. It instead sets a parameter for the factual inquiry as to see, so this is the starting point. Who else might there be who's potentially exercising control? You're looking at the facts as they stand in practice. It's a factual exercise. I've had a lot of I've seen a lot of cases where they rely on divorce papers, for instance, stating that the father or the mother has sole custody, and that shows sole responsibility. Now, that may be helpful to some extent to confirm or corroborate what you're saying, but it's the inquiry doesn't end there. The judge or the Secretary of State will have to look at exactly what it is that you're doing in relation to the child's life to be satisfied that you have sole responsibility. So divorce papers and legal obligations are simply not enough to discharge that burden, and it's important to bear that in mind, to not be satisfied with just that letter, divorce papers, to say, look, I have sole responsibility. You need to actually show far more than that. Just continuing on with the general principles of sole responsibility, duration of sole responsibility is also something to bear in mind. There is no minimum duration before sole responsibility, you're disqualified from sole responsibility. So for instance, in the Madju case in 2000, here, the mother had exercised sole responsibility for 2.5 months only before the date of decision. And the judge, in the first instance, had dismissed the appeal on the basis that 2.5 months was not long enough of a period to qualify of exercise of sole responsibility. The Court of Appeal said that was wrong. You can't be disqualified from satisfying the sole responsibility requirement simply because of the length of time that person was exercising responsibility. That's helpful, but TD Yemen in paragraph 28 does make a point that it is the appellant's burden, if the period of exercising sole responsibility is exceptionally short or very short, then the burden of showing sole responsibility may be more difficult for the appellant or applicant if it's short. So that's something to bear in mind. And there's nothing wrong, circumstances change. You may have the parent, for instance, your partner or the father or mother of your child may have been taking care of your child abroad, and then sadly the father or the mother may have passed away abroad, and so urgently you need to make adjustments and apply for your child to come to the UK. And in the interim, for instance, you may have asked your relatives to take care of your child. The fact that you've only, for instance, exercised sole responsibility for a month isn't immediately dispositive of the issue. It doesn't preclude you from relying on sole responsibility, but you then have to explain why it's been so short. You have to show the reason. Obviously, if the parent passes away, then you can rely on 2971 D instead of E. But if the parent decides to disappear or whatever reason, the principle still stands that you need to explain the reason for the short duration of exercising sole responsibility. This is another important, I put this under general principle because I've seen this a lot as well. Financial support, and sole financial support in particular, is relevant, and I've highlighted this. But it cannot be conclusive, and it's only a factor. And what I've seen a lot of cases that I've done, obviously, unfortunately, my view is rather skewed because I'm only seeing cases that have gone wrong. But in the cases that have gone wrong and have had to go to an appeal, I've seen that there's been an inordinate emphasis on the sole financial support that is being provided by the parent in the UK. And that is legitimate, obviously, because that's one way of showing it. But in my experience, sole financial support won't usually be enough to show sole responsibility. The way the tribunal would deal with sole financial support, once again, in my experience, is essentially to confirm their assessment as to whether there is sole responsibility or not. If the tribunal is minded to find that there is sole responsibility and there is evidence of sole financial support, then they will say, look, this is consistent. The fact that there is sole financial support, I'm emboldened in my conclusion that the appellant here has sole responsibility. On the other hand, if there is no financial support, the judges are likely to use that to reinforce their finding that there is no sole responsibility, because there is also no financial support. So please don't rely on sole financial support alone to show a sole responsibility. That is really just one very small factor that in practice features in a tribunal's factual assessment. Visits and communications. This is also a very important aspect of sole responsibility. Evidence of frequent visits is something that is very helpful. Much like financial support, actually. Just because you visit often doesn't mean that you don't have sole responsibility. But if there is no visit, or if in the past 10 years you visited once or twice, then judges will use that against you to say that you haven't exercised sole responsibility. And that is consistent with the fact that you haven't visited your child abroad for many years. Now, there may be perfectly legitimate reasons for that. If there are, you need to explain it. For instance, I've put in portion of annual leave. If you're working, then it's highly unlikely that you can visit your child abroad, every 3 months or 2 months at a time. You may be only given 20 days of annual leave, 20 working days of annual leave every year. But then, if you're visiting your child once a year or once every 2 years for 10 working days, 15 working days, it's important and it's worthwhile your time to highlight the amount of annual leave you're given to show that the proportion of your annual leave you're using to visit your child. Unfortunately, the less frequent you visit your child, the harder it is going to be to persuade a judge that you exercise sole responsibility. Again, if you have legitimate reasons for not visiting or only very, very rarely visiting, then this has to go into your witness statement. And I'm going to come to the witness statements in a moment. But please bear in mind the importance of visits and equally communication. I've had many cases where there was no evidence of any communication in the bundle, but then in examination in chief, the evidence is that they communicate every day by telephone, by WhatsApp, by Facebook. I put in Viber here. I know most people don't use Viber anymore, but I've just put it in case people still use it. I think most people now use Facebook or WhatsApp, but it's not a product placement, just putting it there for sake of completeness. Calls and text messages. Evidence of this can be very helpful. And here, in particular, I've highlighted the fact that if you can show through your text messages instances in which you've exercised your decision-making responsibility, then definitely put that in, because that's really helpful for a judge to see on pen and paper, black and white, this is where I've said to my son or daughter, you cannot do this, or this is what I've told the relatives caring for my child that they're not allowed to go on that school trip. That's pure evidence, strong evidence showing, cogent evidence showing that you are involved. You are the person making the important decisions in your child's life. So please provide not all of it, but a sample of your evidence, a sample of evidence of your communication, and certainly your visits. So that's the general principle that I wanted to cover, that I didn't need to go in depth. Now, I'm just going to quickly run through the main examples of sole responsibility, which are schooling, education, medical health, and religious spirituality. This is broadly, I mean, there are obviously other ones. I'm going to touch upon these in a moment, but I'm going to take these through very quickly. So the best way to show that you are the person with sole responsibility is a letter from the school. This is, if you take anything from this seminar today, it is this. You need to get a letter from the school if your child is going to school. It is so extremely helpful. I can't emphasize enough just how powerful a letter from the school is. But simply providing a letter from the school is not enough, because what I've seen in a lot of the letters from the schools it's a letter that confirms attendance, the child's attendance, and that the UK parent is paying fees. But that's not enough. That doesn't show, attendance doesn't show anything. And we've already touched upon the fact that paying fees is not enough to show sole responsibility. So what do you do? First of all, the most important thing is to ask the school to exclude the other parent. And what do I mean by that? If the other parent is still alive and is in the child's home country, then the first question for the Home Office or the tribunal is going to be, where is the other parent? You can say the father or the mother is not involved in my child's upbringing, but that is your evidence, oral and witness statement, but that's not independent evidence. If you get the school to say something like, we have not had any involvement with the father or the mother in relation to this pupil, to this child, that is concrete, independent evidence confirming that the other parent isn't involved. It's going to be very difficult to dispute a letter from the school that expressly excludes the other parent of any involvement. So that is something that I've always advised my solicitors to obtain, a letter from the school that says that they haven't had any involvement. The father, for instance, has had no involvement in the child's with the school in relation to the child, and to the best of our knowledge, for instance, the UK parent is a person who is only responsible for the child's decision making. And that's the bit here about who would make all the important decisions in relation to the child. I've put bonus. If the school is also willing to confirm any instances of requiring the UK parent's consent, that is very helpful. So for instance, if there's a school trip and they require consent for, if it's an overnight trip, for instance, and they need consent from a parent or a guardian, who are they asking? Are they asking the relative abroad, or are they asking you? And if they've asked you, then that is very strong evidence to show that you are the person exercising sole responsibility. Vaccinations also, etc. So this is the kind of thing that you can get the school to say. Detailed witness statement in relation to educational decisions, once again, extremely important. Witness statements are, I think, very underrated, but they can really, really strengthen your case. So in a witness statement, you can explain who chose the school. If you are the one who chose the school, why did you choose the school? What research did you do to choose that particular school for your child? How often do you speak with the school in relation to child's educations and concerns? Who pays for your school fees? Obviously, that's important. Again, consent. I put in the question of consent because this is quite helpful. Has there been an occasion where you've refused consent for instance, the school taking your child on a school trip? I had a client who said, yes, I refused my child to go on a school trip because they were going to a village which I knew was dangerous. So I told the school that they're not allowed to take my child, and my child didn't go. That's evidence of you showing, you exercising responsibility, and in the circumstances, highly likely to assist you in showing sole responsibility. I've put in an asterisk here that you should but prepare to be cross-examined on any issue that you raise in your witness statement. You can be asked about the name of the teacher, the name of the head teacher, how often you speak, etc. So bear that in mind. Next, I know I'm running out of time, so I'm gonna try to rush this a bit. Medical health and decisions. This is also a very important aspect of decision making. If the child has ever been to a doctor, then or GP or hospital, then make sure to get a letter from the doctor. Did the doctor ever communicate with the UK parent? If they did, what was the nature of the communication? That should be in the letter. Did they require consent from the UK parent for any treatment or surgery? Once again, that's extremely helpful. We keep coming back to the question of consent because that is a situation in which you can show you are exercising your sole responsibility, your sole decision-making power. Who paid for the treatment? Again, sole financial responsibility is, at least sole financial support rather, is a factor that the tribunal will have to take into account. Again, detailed witness statements in relation to medical and health decisions. If you, for instance, instructed your relative to go to a particular hospital, decisions in relation to child's diet, if you've ever demanded particular treatment or surgery for your child, for instance, if there's been any issues in relation to braces, contraception, vaccinations, etc. These are all things that should be in your witness statement to explain coherently and cogently how you've exercised your sole responsibility. The more detailed your statement, the higher your chance of success. Simply saying, I am the person making all the important decisions in my child's life is not enough. Everybody will say that. You need to show how. You need to paint a picture for the judge so the judge can see what you're talking about. Next is religious and spiritual decisions. So again, usually a witness statement is often sufficient for this aspect of decision making. But if the child attends church or mosque or synagogue, etc., then why that particular place of worship? How often? Where? So for instance, I've had clients who say, well, I've made sure that my child goes to a church, this particular church, because I know the pastor there, and I used to go there, so I made sure that my child goes there every Sunday. I call my son or daughter to check if he's gone or she's gone, etc. Again, letter from the church or mosque or synagogue confirming attendance can also be helpful. They can say, we speak to the parent in the UK. Those are the three main areas in which you can highlight the way in which you have sole responsibility for a child. Another, just before moving, well, actually I could do this in the same breath. So other decisions you might want to think about: the kind of friends your child is permitted to hang out with. So if you've, for instance, forbidden your child from hanging out with children who you think are not good influence on your child, then that's again you exercising your responsibility, your decision-making power to tell those your relatives abroad to not allow your child from spending time with those people. Same goes with sleepovers, holidays, purchase of mobile phones, use of mobile phones. For instance, if your child has, you see that your child's grades are not up to par, then you might revoke their phone privileges. Are you the one who made that decision? How did you communicate that? Put that in your witness statement. After school classes, makeup, how soon you allow your son or daughter to wear makeup. Those are things that are very helpful. Also, the last point I want to just speak about is any disagreement with those providing day-to-day care. So for instance, if you wanted your child to, let's say, stop hanging out, you didn't want your child to go on a sleepover, but then your relatives caring for your child said, well, I think they should be able to. But then you've overridden them and you've said no, and as a result your child has stayed and didn't go on a sleepover, then that's really important, because that shows that you are the person who's making a decision, not the carers abroad, but it's you. And so putting that as an example in your witness statement, again, is very helpful. So just to sum up in relation to the decisions, one thing you need to bear in mind, you need to hopefully you will take away from this, is the importance of witness statements. And putting that in really can make a difference between winning your case and losing your case. Obviously, I've been speaking about single parent cases when the other parent isn't involved. I'm just very quickly going to touch upon two parent cases. So for instance, if you're in the UK and the other parent is abroad and the other parent is somehow still involved in the child's life, hasn't completely abdicated responsibility or responsibility, then those are two parent cases. And TD Yemen says in those cases, a starting point is that they share responsibility. So in other words, no sole responsibility. And in those cases, two parent cases, the family will be split up only because all the circumstances, including child's best interest, require such a result. And this is under 2971F, which is even though you in the UK, the UK parent doesn't have sole responsibility, there are compelling and compassionate circumstances which make the child's exclusion undesirable. But this is a very, very onerous test. So here you see from the case of Mundeba in 2013, has given some examples. Again, this is not exhaustive, but for instance, if the child is living in an unacceptable social and economic environment, there's evidence of neglect or abuse, there are unmet needs, there are arrangements for child's physical care in the UK. So for instance, if the case is that the mother abroad, there is a mother abroad who's loosely involved, but she is abusing your child abroad, or there's evidence of neglect, then even if there is some sharing of responsibility, you might be able to show that your child should be granted entry clearance to enter the UK under paragraph 2971F, because there are compelling compassionate circumstances. But you really have to then show that by evidence, by documentary evidence and detailed witness statement. Concluding thoughts, again, detailed witness statement is key. Explain how decision-making power is being exercised. But the important thing I want you to also do is obviously exclude the other person, exclude the other parent. Get a letter from the school and exclude the other parent from any decision-making or involvement. If your child is old enough, a statement from them can also be helpful to say, I haven't seen my father, I haven't seen my mother since the age of 2, for instance. That could also be corroborative. I've said already, another letter from the school is a necessity. Try to get them to exclude the other parent or the carer from any decision making. And finally, try to make the entry clearance application as soon as possible. The sooner you make it, the better. If you've left the UK 15 years ago and now you're making the application as the child is about to turn 18, automatically that rings alarm bells for the Secretary of State and the tribunal. Obviously, if there are explanations, for instance, because of immigration status, you only got indefinite leave to remain a year ago, then fine. Financial constraints, change in circumstances, etc. This has to be made clear in your witness statement, in your representations, in the documentary evidence. But even then, I've had cases where there's been an immigration status issue and they were granted indefinite leave to remain, and then afterwards they made the application 2 years later, right before the child turned 18. And the judge was skeptical of that, rightly or wrongly. The reality is that judges often are going to be very skeptical of evidence. Again, rightly or wrongly. It's unfortunate, but that's the fact of the case. That's the reality. So we have to work to subdue that skepticism that is displayed by a judge. And so if it's taken you 2 years, you might want to explain why. Financial constraints, often really legitimate. These are expensive applications. You might not have the money. So make sure to explain everything in your witness statement and engage your lawyer, engage your solicitors. And solicitors, please feel free to speak to barristers you intend to instruct and get their thoughts on how to draft a witness statement. If there's anything else that should go in it. Often barristers, certainly at Goldsmith Chambers, we're happy to be involved at the beginning of the case, really. And I certainly am happy to be involved and take a collaborative approach to preparing an appeal. So please be proactive with the barristers as well. So that concludes my webinar. Thank you so much for all of you listening. I'm just going to take a quick Q&A. So I have, I think it's this one. Sorry. So does the case of Mundeba cover all Article 8 aspects? Well, case of Mundeba is helpful because you are, in an Article 8 case, let me put it this way, in an Article 8 case, I don't know if you can actually see the answer, question, but I'm just going to read it again. And you've seen my poll just show up, I think, because I'm told that the time is running out. Just very quickly answer the question. Does the case of Mundeba cover all Article 8 aspects? So just going back to Mundeba very quickly. Mundeba says, Mundeba says, Mundeba is specifically in relation to paragraph 2971F of the rules. If you're looking at Article 8, these considerations are necessarily going to be relevant. But what's helpful about paragraph 2971F is that, you know, if you succeed under the immigration rules, then we know that that's dispositive of the appeal, of the Article 8 appeal. And often we say, don't worry about the immigration rules, just go straight Article 8. But here, why Article 8 why the immigration rules could be more important or helpful is because under the immigration rules, even if your child turns 18 in the course of, let's say you make an application when the child's 17, and by the time the appeal comes, the child is now 18, then under Article 8, outside the rules, you have to consider the fact that the child is now over the age of 18 and an adult. And that can potentially be an adverse consequence. But if you try to persuade the judge under the immigration rules, then the rules, I think paragraph 27 of the rule says if in an entry clearance application, if you make an application while the child's 17, then you continue to treat that child under the age of 18 until a decision is taken. So for that purposes, while Mundeba is obviously relevant in an Article 8 scheme, so it's within Article 8, it's not necessarily relevant, it's highly relevant in an immigration rule context. So hopefully that answered your question. Brilliant, thank you so much. I think that those are all the questions that I've received. I've received some requests for the slides to be sent. I will send my slides to the email addresses that you just sent me. And please complete the polls. Thank you very much for your time.